Hello everyone, my name is Fuseni Wa Salifu. I am the CEO of Land Reality Consult. Land Reality Consult is a consulting firm dedicated to promoting geographic information system, remote sensing, land administration and land governance issues, estate agency. That is, if you want to buy landed properties or you want to sell landed properties, kindly contact Land Reality Consult. If you want to also learn more about these thematic areas above, kindly subscribe to Land Reality Consult. Today I'm going to talk about the new Land Law 2020 Act 1036. In my previous video, I talked about the reasons why the Act was enacted by Parliament of the Republic of Ghana. So this video, I'm going to concentrate on the historical perspective of this new land law. And I will also highlight some of the major features of this new land law. This act was enacted by Parliament of Ghana on 23rd December 2020, meaning that it was on the 23rd December 2020 that the President of the Republic of Ghana, Nana Addo Akufo-Addo, signed the act into a law, or signed the land bill into an act. So that is it. So this preparations for the enactment of this land act started very long time, about a decade or 2 decades ago. And all this started because of their enormous problems that characterize the land administration system of Ghana. This has been well captured in the National Land Policy of the Republic of Ghana, which indicates that there are a lot of challenges associated with our land administration and land governance system. And some of these problems are indeterminate boundaries of stool, skin, family lands. We have a lot of encroachment of states' lands. We have land disputes and land conflicts. We have lack of coordinated geographic information systems, to just mention a few. These are some of the problems that were highlighted, and a lot of intervention came along the way to solve some of these problems, but could not. And one of the interventions was the land administration project, which came with the aim of solving some of these problems, but could not. But however, also done some successes, or achieved certain successes in certain areas, like the regulatory framework, that they came up with a new act that harmonized the institutional framework of the social framework governing land in the country. So this land act started, as I indicated, about a decade or 2 decades ago, and a major milestone was achieved in 2017, where a stakeholder engagement was organized to solicit views from people about the land bill. So a lot of people made contributions to shape the land bill, and it was submitted to Parliament in 2018. So for rigorous debate, and the Parliament of the Republic of Ghana did a very important work by looking at the land bill, restructure it, add certain things, subtract certain things, and make it a very good land bill, and it was approved by Parliament around July 2020, and it was submitted to the President, and the President signed it into a new Land Act on 23rd December 2020. So basically, that is the historical perspective of the new land law. So now I will talk about some of the major features of this Land Act. And one major feature of this act is the accountability of fiduciary holders. You know, fiduciary holders, these are people that hold land on behalf of larger communities or larger members. So a typical example of a fiduciary holder is a chief or a family head. So the act is saying that there will be some kind of accountability of these people, meaning that they are holding the land on behalf of the people. So if there any transaction on that land, they should be accounted to the people. So it's very straightforward. And in the past, chiefs and family head unilaterally sells land without accounting to their members. But this act has made it a mandatory, and there are very severe offenses if chiefs or family heads do not account to its members. And the second feature of this Land Act is the creation or strengthening of the customary land secretariats. You know, land administration project, that's one of the successes of land administration project. Land administration projects establish some customary land secretariats to record land transactions at the customary level. So this Land Act has also given an echo with respect to establishing new customary land secretariats. If you families, customary institutions are mandated to set up customary land secretariats to record their land rights. And this is in line with the continuum of land rights, which talks about diverse land ownership within a continuum. And the recordation of land rights will start from the customary land secretarial level, and that will be the lower level, and then to come to the Lands Commission, that will be almost at the higher level. So the second point, as I indicated, is the Act creates the customary land secretary. It imposes an obligation on stools, skins, clans, or families to establish customary land secretary for the management of their respective lands. Currently, there are about 90 customary land secretaries that has been established. Some of them are not operational, but majority of them are actually operational. So this Land Act has strengthened customary land secretaries to be more effective and efficient in the recordation of land rights at the customary level. So the second feature of this Land Act is that the use of alternative dispute resolution mechanisms for solving land disputes. You know, in the national land policy, as I indicated, land disputes and conflicts was highlighted as a major challenge or problem facing the country land administration domain. So and about 60% of cases in Ghanaian courts relates to land issues. So there are a lot of huge cases in the country legal system that pertains to land issues. So the act is saying that courts should be last resort for solving land issues. So the act enjoins us to use ADR mechanisms such as arbitration, mediation, reconciliation to help us to solve some of these issues. And these ADR mechanisms are usually cost effective, they are less time consuming, and they are flexible. So these are advantages of the ADR mechanism that the New Land Act wants us to leverage on. So the ADR Act was also passed. That is, the Act is Act 792 to resolve dispute emanating under the Land Act. So we should make good use of this ADR mechanism in resolving land conflicts. The new land law also made provision for record 3 levels of registration of interest in land. One is recording of interest in land by customary land secretariats. Secondly, it's also talk about registration of instruments, and thirdly, title registration. Meaning that first of all, recordation of interest should be done by the CLS at the customary levels. That will help to prevent double sales of land. That is it. And also registration of instruments, dates, and then title registration. You know, title registration is mostly done in Greater Accra region of the Republic of Ghana, and some small portion of Kumasi, and some small portion of Cape Coast, and the rest of the country. Recordation or registration is the deed system, not the title. So that is it. So another important feature of the New Land Act is the spousal protection. This act highlighted that if you are married, legally married with someone, then you cannot unilaterally transact on your land, because the property or the land is jointly held. Both of you are holding the properties as joint owners. So if you want to either mortgage, you want to sell, you want to transfer your interest to another person, you need express consent in writing from the other party before you can transact on the land. So, however, if you have acquired your properties before the marriage, then the property is not held as a joint property. So that is it. And then we also have another feature of the New Land Act is that a non-citizen of Ghana cannot hide under the cloak of marriage to acquire interest in land more than 50 years. You know, foreigners that come to the country can acquire interest in land, but it should not be more than 50 years for residential. But for other land uses or other land use types like agriculture and so on, the term of the lease can be less than the 50 years. So the act is saying that if you are married to Ghanaian, you cannot use that to acquire a property more than 50 years. So it is clear, there's no any ambiguity with respect to this provision. Another important feature of this act is that state has the power to compulsory acquired land for public interest, and that was then too, as it is enshrined in the Constitution, the 1992 Constitution of the Republic of Ghana. The government has the power to compulsory acquire property in the interest of public peace, public morality, health planning, or national defense, to acquire those kind of property for those purposes. But in doing so, the government should pay prompt and adequate compensation to the affected victims. If the government wants to do a resettlement, then those people should be resettled with due regard to the social and economic and religious background. So that is the 1992 Constitution of the Republic of Ghana. But this act also emphasized on this. But in those days, or before the inception of this act, compensations has not been paid for many of the acquisition that have been done by the government. And those that compensation has been paid, sometimes it takes ages or takes longer period of time for the government to pay compensation to the affected people. So this does not adhere to the 1992 Constitution that advocates for prompt, fair, and adequate compensation for the affected victims. So this new Land Act sought to resolve that issue, and the act indicated that before government or any government institution acquired land, then they have to make sure that they have enough funds. There should be proof of availability of funds, and the funds should be kept in an escrow account that is interest yielding, and it will be managed by the Lands Commission before the Lands Commission can even think about whether it is okay to acquire that land or property. So it is a very important, and this provision, if it is well implemented, the adequate, fair, and prompt compensation payment as enshrined in the 1992 Constitution will be fulfilled. So another feature of the new act is that is tool, skin, claim, or family which has allotted title to land cannot alienate without the consent and concurrence of the Lands Commission. If you are transferring tool, skin, or family lands, you need consent and concurrence of the Lands Commission. In the past, family lands were not part. Families' lands were not part of the concurrence of the Regional Lands Commission. It's only stool or skin lands that sought concurrence and consent from the Lands Commission before registration or alienating the land. Another feature of the new Land Act that says that the activity of person referred to us as land gas has been criminalized under this new Land Act, meaning that people that serve as land gas has been criminalized. And also people who engage land gas to unlawfully protect their lands has also been criminalized. So that is it. And there are very huge offenses associated with this act. I have talked about the offenses of this act, or I will talk about the offenses associated with this act in the next video. And also people who exercise adverse possession over land for 12 years asset title, that was then, meaning that if you settle on a piece of land uninterruptedly for more than 12 years, you assume the role of the owner of that piece of land. That was then, that is according to the Limitation Act. But now it is prohibited. If you cannot claim ownership of land based on the Limitation Act because it has been repealed. So the act indicates a person who exercises adverse possession of a land for 12 years asset title to the land through adverse possession. As I indicated, that was the position of the law then. The position was that limitation or prescription operates against the state. So the current position is that the Limitation Act 1972, NRCD 54, and any other laws on prescription shall not operate against the state. And the act further indicated that a person shall not acquire interest in public land based on prescription or adverse possession. And the act further indicated that unlawful occupation or sale of public land has been criminalized to deter persons who unlawfully possess public land for 12 years or more from asserting adverse possession through Limitation Act. So that is the position. You cannot claim ownership with respect to a piece of land based on limitation decree since it has been repealed. And another feature that is very important to talk about is the automatic renewal of the lease term. Now, I have talked about some of the major features of the Land Act, 2020 Act 1036. There are some more, but these are major features of the Land Act. And in conclusion, I would say that this is a very good act, and if it is well implemented, it will solve most of the issues that were enumerated in the Ghana National Land Policy of 1999. So this act needs everyone to come on board for it to be more effective and efficient. And this act needs nationwide education. People should be educated on the provision of this act so that they would understand the act better, and where some of the provision of the act has been violated, they can take the people on. Thank you very much for listening and watching this amazing video. Kindly subscribe to my YouTube channel for more educational videos. Thank you very much. Bye bye.